handgun.
Breaking news. In a 5-4 decision, the Supreme Court in the District of Columbia v. Heller held that the Second Amendment of the Constitution does in fact guarantee the individual right for people to own guns for the purpose of self-defense, reversing the previous gun ban. DC's lack of statehood, however, does not incorporate the Second Amendment to the states. We will see where this takes us.
Hi, sir. How are you doing today?
Not good. I want a gun.
Sure. What kind, sir?
A handgun. My shotgun ain't fast enough.
Sorry, sir. Handguns are not to be sold for individual purposes or self-defense in the city of Chicago.
What kind of stinking rule is that? How am I supposed to protect my family?
A few moments later.
Lydia from the Castellari News Network, and we have breaking news. Today is June 28, 2010, and one 76-year-old hunter named Otis McDonald has made history at the Supreme Court with his case McDonald v. Chicago. McDonald, who lived in Chicago, wanted to have a handgun for self-defense to protect him and his family in their home. He lived in a neighborhood that had grown increasingly troubled with gang and drug-related violence, and believed he needed a handgun to protect his wife and his family after his home had been broken into several times. He already had several shotguns, but believed a handgun would serve his purposes better. Because the city of Chicago had strict rules barring handguns, he and 3 other Chicago residents brought their case to the district court. Now, it's made a step toward revolutionizing gun rights. Back to you, Seda.
The Supreme Court, in a hasty 5-4 decision, answered a key constitutional issue. Can the Second Amendment be applied to the state level through the 14th Amendment's Privileges and Immunities Clause or the Due Process Clause? And is the Second Amendment, the right to bear arms, a fundamental right? With an inside look into the Supreme Court, here's Sophia and Lydia to walk us through it all.
McDonald argued the Second Amendment needed to apply to the states, per the 14th Amendment's Privileges and Immunities Clause and the Due Process Clause. McDonald said the case was erroneous and stare decisis from previous cases should be overcome. He said courts should consider the historical acceptance of the Second Amendment and its recognition by states. McDonald additionally argued that the right to bear arms is a fundamental right of self-defense, which states should not infringe upon.
And on the other side, we have the city of Chicago. They argued incorporation should be rejected, referencing the slaughterhouse cases, which had upheld that the Privileges and Immunities Clause only applies at the federal level. They argued that there would be huge repercussions for federalism if incorporated. States should be laboratories of democracy, they said, and local governments have a better and more intimate understanding of their own problems. Gun regulation should be tailored based on local conditions, they say.
Now, in the end, the court ruled in McDonald's favor. The majority opinion concluded that the Second Amendment's right to bear arms was applicable to the states, and therefore, it was selectively incorporated through the 14th Amendment's Due Process Clause. Justice Alito stated that the right to bear arms is deeply rooted in our nation's history and traditions, and is a fundamental right. While owning a handgun is legal, it is well within reason for states to require an ID, a background check, and/or a firearms test. Back to you, Lydia.
Thank you, Seda. Chief Justice Roberts and Justices Scalia, Kennedy, and Thomas all concurred with Justice Alito. A major point they added is that self-defense is a basic right, which the Heller Court noted was the central component of the Second Amendment's right to bear arms. Not only did the justices follow stare decisis, they also expanded on the Heller principle and made it binding at the state level.
Justices Stevens and Breyer dissented. Relying on judicial restraint, Justice Stevens argued that the main question of the court was whether or not an individual has a fundamental right to own a firearm in their home. He states that this was answered in Miller v. Texas, which decided that an individual cannot possess a firearm in their house. Justice Breyer, joined by Justices Sotomayor and Ginsburg, noted that the Second Amendment's right to bear arms is not fundamental and therefore should not apply to the states through the 14th Amendment.
Although McDonald v. Chicago did not explicitly overturn any Supreme Court cases, it did reverse the Senate's Circuit Court's decision. The court's decision was viewed as a symbolic victory for gun rights, and almost immediately after the decision, Chicago's mayor promised to create a citywide gun registry so that law enforcement officials and emergency responders know which homes have firearms before entering for their safety.
Additionally, new proposals for gun regulations were introduced, including the one gun per owner rule, safety training, liability insurance, and banning gun shops in the city. The door has been open for new cases and controversies around gun rights, including a ban on bump stops and requiring mental health checks. As of this moment, gun rights activists have won a small victory, but its future still remains in limbo.
This is Seda and Lydia
signing off.